होइन नि मध्यरात चाहिँ अलि होइन बिहान चाहिँ 4 बज्दैछ 3 बज्दैछ हाम्रोमा अहिले चाहिँ बिहानको one of the thing I don't really know how तपाईँले मेरो स्क्रिन देख्नु भएको छ
देखिएको छ एउटा कुरा शेयर गरौँ है
थ्याङ्क यू
केही
हजुर
रिटायर न्यायाधीशहरू हामी यहाँ सहभागी को छौँ तपाईँले यहाँ सबै देख्नु भएको छैन हामी केही रिटायर न्यायाधीशहरू सिनियर इन्जिनियरहरू सिएहरू अनि ब्याङ्कर्सहरू विभिन्न विधाका यहाँ जुटेका छौँ 30 जना छौँ 34-35 जना हामी यहाँ अगाडि छौँ तपाईले नदेखेको हुनाले मात्र मैले यति बताइदिएको
हस् न धन्यवाद भाइ धन्यवाद अब एउटा कुरा चाहिँ अब मलाई अलिकति म नर्भस पनि भएको छु हामी चाहिँ त्यहाँ धेरै एक्सपिरियन्स्ड सबैजना छौँ फेरि पनि ठिकै छ म चाहिँ सानो यो चाहिँ मेरो सानो एउटा प्रयास रहेको छ यहाँ सो मलाई चाहिँ यो पहिला हामीले यो इन्टरनेसनल रिजनल इन्स्टिट्युसनले आर्बिट्रेसनको एडभान्समेन्टमा के रोल प्ले गरेछ भन्ने कुरा चाहिँ मैले त्यो हामी दाइसँग कुरा भइरहेको थियो अनि यो विषयमा ल कुरा गरौँ भन्दाखेरि चाहिँ नि I was really struggling where to start with when we're talking about international and regional institution and arbitration. So I didn't really know where to start with. So for that reason, I decided to look into a kind of first introducing the arbitration. Having said that, I'm not going to try to define what arbitration is, and because that would be waste of the time, because we all know what arbitration is. But before I start, I wanted to start with this one, although this particular statement wasn't probably to do with real arbitration, commercial arbitration. It was meant to more focus on arbitration between states and other sort of battles. So this is Benjamin Franklin's statement, where he mainly looked into trying to focus on arbitration as a main method of resolution of a dispute. Although it wasn't focused on commercial arbitration, this is very, very kind of a this sets a kind of a philosophy of arbitration, because if we try to settle the dispute in the court, particularly in the commercial disputes, we're probably not going to be going to go anywhere. So that is why Benjamin Franklin was trying to put this thing, saying that where settling the disputes become so difficult, then we probably have to resort to arbitration. That would be the best win-win for everyone, because arbitration is not only a legal it doesn't only look into the legal aspect, but also looks into best negotiated commercial aspect in many ways. So that is why he was trying to argue that nation and mankind, they need to, rather than fighting with each other, try to resolve the dispute through arbitration, and that becomes very, very important in commercial disputes as well. And where I work is construction dispute quite a lot. And in those areas, arbitration becomes one of the most prominent way of resolving the dispute in many ways. So when we look into that's what I wanted to start and move into this kind of the philosophy of arbitration. When we say arbitration, I was looking into the English Arbitration Act and how that came into, and was trying to look into what was the philosophy behind the 1698 Arbitration Act, which was, 400, nearly 400 years ago. The Arbitration Act was introduced in the UK, in the English legal system. And I actually found the root of that arbitration in John Locke's, the Scottish philosopher, who is very, very popular on particular in political morality. So he wrote on his second treatise of the government, that the arbitration, the is basically the one which needs to be the mainstream, rather than, going to the state sponsored court system. And the philosophy behind that is, when you have an arbitrator deciding the case, that actually have a broader perspective than a judge who is typically trained in a legal education only. That said, he wasn't trying to undermine the role of the judge and the capacity of the judge to, basically to decide a case. But then what he was trying to do is, when you go to a judge or a court, on this particular philosophy, when you go to a judge or a court, you are going into a very strict legal framework, where the judges does have so many limitations, as well as, there is limitation of the process and procedure. Whereas when you are going to go into an arbitration, what he was trying to explain on this particular, this is chapter 14 of his second treatise of the government. What he was trying to explain here was mainly looking into, when you go to an arbitration, one, there is full party autonomy. So you want to, the parties could dictate, I wouldn't say the dictate, but parties could guide the arbitrators or arbitration tribunal on what are the issues that they are, not agreeing with each other, and beyond their legal rights and the duties, and what are the issues that they wanted to, the arbitrator to award on, or to, let's put in a judicial way, to rule onto it, although we don't really say that way. So that was the one of the thing which the 1698 Arbitration Act put into. The philosophy comes from, the parties having their own autonomy in deciding, or, resolving the dispute, between themselves. And one of the things which really put the, put into the heart of that 1698 Arbitration Act was, the neutrality and impartiality. So impartiality, we do not, we could be talking quite a lot about impartiality, because there is no objective measurement of what is impartial and what is not. But then the English law and John Locke's philosophy itself looks into the fairness, which is been one of the core philosophy of arbitration, not only in 1698 Arbitration Act, as well as in 1995 Arbitration Act, as in these. So that has become a core of the arbitration. And one of the things is what we call, is the equality of the arms, basically looking into the procedural fairness. And that's where we have the court coming into, where, there has been some issue with the fairness. Having said that, I'm going to talk about that slightly later on. The English court has been quite reluctant to, to interfere on arbitration proceeding as well as in the process of the arbitration. But then we'll talk about that slightly later on. So one of the philosophy where we are looking into the arbitration is also the internationalism, the boundaries, cross boundaries disputes, and the effect of this. Particularly, most of us know about New York Convention and how an arbitral award could be enforced. So for those reasons, I'm probably not going to be talking about all these things because these are the general principles of the arbitration, and that's where the philosophy draws upon. So that's kind of a wanted to dig into a little bit of what's the philosophical backing of the arbitration, and I was quite impressed on John Locke's philosophy 1698 itself, and then how the arbitration was progressing. So the reason I did talk a little bit about that philosophy is simply to see like how grounded it is in common law system, that how grounded the arbitration is, and how the arbitration has played into kind of a historical development of the arbitration. Now the next thing is, yes, arbitration, that's the philosophy of arbitration. It's beautiful. It's like, it's commercially working. It's great. But then how do we actually put that into, because whenever there is something, whenever people get a power, there is always the power. We know that power makes a man. It's not a gender based. Power makes a man corrupt. When I say corrupt, it's not about the financial corruption, but then a kind of a irregularities it brings into. So for those reasons, that's where we are looking into like the role of the institutions. Because if there is no institution, then maybe although the party have full autonomy, then and that's one of the philosophy of the arbitration. But then how do you ensure the fairness within that full autonomy? Because wherever there are we do talk about. I was talking in a different conference yesterday, day before, where we were looking into some of the vitiating factors of the contract, particularly in construction, and then we were talking about whether the no claim certificates in construction, where a contractor does have to get paid, let's say £2 million, but then and then sits into the negotiation with the employer saying that, yeah, I'm actually going to get £1 million from you now rather than waiting 6 months or 9 months, and then issue a no claim certificate, and then whether that particular agreement becomes valid or invalid under the vitiating factors of the contract. Looking into like there is kind of a power relationship, there is kind of a kind of a coercion put on undue influence, and everything actually comes into it. So that's kind of an example where we try to put a party autonomy, because both of the parties in arbitration proceeding as well as in a contract may not be in equal footing. So that's where the institution comes. That's why I was thinking why an institution matters. That's where the institution comes. Because if we try to look into ad hoc arbitration, that problem of fairness and neutrality, that may come into the scene. So for those reasons, the institution matters. So arbitration institution has always been providing kind of a structured framework, and then also, although there are arbitration act, the institution does provide a very very specific procedural safeguards. So that is why the institution matters. Also, the institution also matters on things such as, ensuring the expertise. So pool of arbitrators, and then they have expertise in particular area, and then they also matters on the things such as enforceability. I just sit and work quite a lot of adjudication, particularly where the dispute is construction. And one of the thing in Construction Act in the UK is that, the adjudicator's decision is effective only until it's challenged either in the court or in the arbitration. So let's say if there is no institutional background or backing on that sort of adjudication setting, then it's a lot easier to challenge those adjudicators' decision. Whereas if there is a framework, such as I work within the framework, there's the Chartered Institute of Arbitrators, and then there are things such as Royal Institution of Chartered Surveyors, which does have a dispute resolution wing, a separate dispute resolution wing for construction disputes. And then when you come with the backing of those sort of institution, the challenging those decision becomes slightly onerous, if not difficult, if not impossible. So it becomes slightly onerous, and this is where the institution comes into. So basically, most of the institution, internationally and regionally, has acted as a gatekeeper, guiding the process, and not really the outcome, but the process of arbitration. When the process is fair, then the outcome becomes fair as well, or fairer as well. So that's basically why institution matters. So what these institutions does, and I'm going to go and delve into what we are doing in our own setting, the NIAC, the Nepal International Area Center. But then this is basically what the arbitration institution's function has been, such as administering the proceeding, helping to appoint the arbitrators, like, keep a roster, pool of arbitrator, and provide, because it's easier for people to parties to go to the institution rather than to an individual for those. The institution have been making and developing rules, which is also a lot of institution. We do a lot of research within those, and then try to improve the rules. Things such as support services, in many Western countries now, they have started looking into award enforcement, although they don't have their own apparatus such as the the enforcement mechanism, but they have started the court has started, giving some of the power. There has been a case where, in the recent case, which is not published yet, where the court has said that rather than coming to the court, the parties should be, the arbitrators should be giving a specific direction for the parties to, in they enforce the arbitral award. So these are the things. And then one of the things the institution has been doing is developing people, developing the process. So these are some of the things that the key functions that the arbitration institution has been doing. So I could not probably look into, because now we are so connected globally, particularly after the World Trade Organization, the invent uh, yeah, the World Trade Organization. We are so much connected, and now we are looking into the age where the technology has been dominating everything. So for those reasons, it will not be possible to look into all international arbitration institutions. But then we these are some of the institutions. I'm probably not going to talk about all of those, but then look into few of these. So these institutions has actually played a vital role in development of arbitration, advancement of arbitration in concept as well as in practices on this. So one of these, the International Chamber of Commerce Court of Arbitration, this ICC, it doesn't stand for Cricket Council. I remember in around 2001, I was a member of the International Court of Arbitration, and then one of my role as the member was to look into. We developed a number of things such as Incoterms 2000 was one of the things which I was involved, and small claim arbitration guidance, which I was in the team on developing that, and in year 2000, 2001. But one of the things which I used to go on do around like Europe was going and talking about the ICC rule of arbitration, and then people used to ask me, "Oh, you're from International Cricket Council." That's why they changed the this thing, the logo later on. But anyway, that's only something. But it's basically they focus into things like commercial and investment arbitration globally. They've got a global network, and one of the things they are doing is providing the trainings and providing the pool of arbitration globally. And then there is this thing, London Court of International Arbitration. You may be surprised, um, what happens in the UK. What I have seen is you have parties from two different countries which has got no relationship with England or London or English law, but then you still have parties choosing London as a seat of arbitration and English law as the procedural law. And then when I was looking into why, because a party from, let's say, South Africa and a party from Saudi Arabia, they don't have any relationship with English law. Why they choose London as a seat of arbitration and English law as governing law? And one of the things I was talking to a lot of the um, the barristers who get involved, QCs who get involved in drafting those, negotiating those contracts. And one of the things they told me was because the English court is very, very good on enforcing the foreign laws. And also another thing they were looking into is the framework of the court's approach of not interfering in the arbitral proceedings. So that was the reason why they choose the London as a center seat of arbitration. The reason I'm talking about this, particularly saying this, is because one of the things which we could probably encourage, international parties to come to Nepal as a seat of arbitration. We probably need to, I wouldn't use educate, probably would be a very strong word, but create an awareness, particularly between our judges as well as the practitioners on around how we could promote, Kathmandu as a seat of arbitration. So that's why I was giving this particular example of London Court of International Arbitration and how foreign parties who have got absolutely no relationship with the place as well as the legal system and the English legal system choose English law as a governing law and London as a seat of arbitration. So we have these like SIAC, Hong Kong International Arbitration Center, SciTech, which is now one of the biggest, because where there is Chinese parties' interest, they are involved. So these are, and then American Arbitration Association. So there are like these are some of the international institutions. But one of the institutions I deliberately left in the last slide was the Chartered Institute of Arbitration, because this is one of the leading international institution which provides a kind of a global center for excellence by providing things such as the trainings, and providing the all those sort of things. So training and accreditation, setting the global standard, also providing the professional development. And nowadays they are looking into how artificial intelligence could be integrated in the arbitration. This doesn't mean, when you that last one, the AI integration, it doesn't mean the chatbot deciding the case and making an award. This is more, I've been involved in a lot of, because I'm actually writing a monograph at the moment, a research book on how to regulate the artificial intelligence, particularly from the perspective of the liability. Um, so I've been involved in a lot of discussion on these AI integration, artificial intelligence integration. So AI integration in most of the legal system, we do have a project with the Supreme Court of the United Kingdom as well, on looking into how AI could be integrated in the judicial system. One of the lead researcher on that one. So what we are looking into AI integration is, AI could make the arbitrator's life a lot easier, but can you depend on the generative AI on getting the information for you as an arbitrator? You could look that as a tool of research, and we cannot avoid that. It's already there, and we should probably take advantage of that. But then, as an arbitrator, arbitration is a business where the stake is big, the risk is really big, and then you cannot rely on artificial intelligence. So there is a human input needed on checking those information whether they are accurate. And also, the artificial intelligence hasn't been to that level where they could actually interpret the law, or the judicial decision to that level where it could actually make a fair decision. So for those reasons, it's still this it's way it's quite far away from AI replacing the human arbitrators. And so that probably, when you say not in a near future, it the some human intervention would still be needed even in future on this one. But that AI integration is basically looking into preparing a comprehensive guidelines on how we responsibly could use the artificial intelligence, particularly in arbitral proceeding, in procedural aspect, rather than actual award writing and making a decision. So it's those, but there are challenges with the use of AI, because one of the challenges is about the data security, the efficiency of that, and how transparent, because one of the philosophy of arbitration is about transparency, and how transparent that process is going to be is one of the biggest challenges. So these are like some of the things now, the institutions where Chartered Institute of Arbitration was established in 1915 to provide a kind of to act as a global center for excellence, which was basically, training the arbitrators, sharing the good practices and those things. Now looking into, providing or developing a guidance on how artificial intelligence could impact as well as could be regulated within the process of arbitration. So these are like some of the roles, and how they promote on this. This is another one. The reason I'm talking is because one of the thing is uniqueness of the ICC arbitration. So, International Court of Arbitration, one of these things is ICC stands for three things: global reach, because it has got membership across the world. It does have a rigorous rules to follow, particularly in procedural rules. How do you appoint the arbitrators, appointing arbitrator, appointing authority, and those things. And one of the most important aspect of this is the scrutiny of award. The the Article 34 of the ICC Rule of Arbitration requires that every arbitral award to be scrutinized by at least two experts before it's been handed down to the to the parties. So that actually, there's still a very big debate on where the arbitrators appointed by the parties have already made a decision, already made an award, why it goes to someone else for this scrutinization. And then that there has been some issues about breach of confidentiality at the same time. And then there has also been the issue about, then if you need somebody else to scrutinize the award, then why you need an expert arbitrators, or how do you rely on arbitrators' decision, because if that needs to be scrutinized. But the whole idea of scrutinizing, whole idea of Article 34 of ICC rule is that, the arbitrators sometimes are not legally trained. So if they are, let's say, I'm not trying to undermine the legal knowledge of engineer or accountant friends. They are great. They do understand the law as much as the lawyers do understand. But at the same time, if the background isn't on, particularly when you go and try to get the membership of Chartered Institute of Arbitrators, one of the things is you need to look into the law of the obligation. And from that perspective, the arbitrators, so the reason why you have this scrutiny is, the arbitrators don't make that mistake. So for those reasons, that's one of the thing which is unique about ICC rule, and that makes ICC rule very, very popular across the globe. And that's one of the things the institution could provide. Not only provide the pool of well-trained arbitrators, but also provide kind of a security for the parties that, yeah, the award would be, right, and the award would be enforceable. So that's basically how we look into. And there are some other institutions, such as London Court of International Arbitration, which does have a flexible rule, the American Arbitration Association, or International Center for Settlement of these investment disputes, and those, Permanent Court of Arbitration, the Hague, which is the state arbitration, and those, and then most importantly, we all know about Singapore International Arbitration Center, so which has actually started providing the emergency arbitrator provision where the arbitrator step down, or those. And we have, these are like some of the international institutions I was looking into and how they have contributed in advancing the arbitration. But now we have regional business hubs and also regional arbitration institution. So this is the China International Economic and Trade Arbitration Commission, which is a leading arbitration center in Asia Pacific. And one of the things they are doing is not only promoting the arbitration, but also assuring the parties, particularly the foreign investor coming to China, that their dispute will be fairly resolved. That puts a kind of confidence on the investors to come in. And this is also the Stockholm Chamber of Commerce Arbitration Institution, which is basically looking into trying to fill the gap between common law and non-common law system. So it's very, very popular on kind of east-west disputes. So where there is, the whole idea of even the contract is different between the civil law and common law. One of the example you all know probably is that, in common law, a, a contract is not valid without consideration for both of the party, whereas civil law doesn't actually look from that perspective. So these are like some of those, the what we call the conceptual differences, and the Stockholm Chamber of Commerce Arbitration Institution has put some guidance on how to deal with, two different type of legal system. This is African one, which is harmonization of business law in Africa, organization of the harmonization of business law in Africa, big continent, different, the particularly the national laws, and then it was particularly hard. So they were looking into yeah, um, based the looking into mainly, how do you deal with those legal system differences between the countries. And we have some specialist organizations such as the intellectual property one, WIPO. They have specialized intellectual property arbitration because it's quite harder. So we do not probably have a concept in Nepal, but we probably need to think about that one. That's why whenever I talk about construction law, I always don't forget to talk about, how technology and construction court in the UK has contributed in settling the construction and intellectual property dispute, because they are expert on those area, and judges are trained on those particular area, and how they look into focusing in those, because they are very complex. The relationship is very complex in those. So we have our own, the last three are not the least, but most important in our context, the NIAC, APCAM, and NEP, and we have NEPCA in Nepal, Nepal Council of Arbitration. I'm probably not going to talk much about those, but then I was looking into how, as NIAC, I'm one of the member of the NIAC, and how we are trying to, you know, contribute in development of arbitration as not only as a profession but as a method of dispute resolution in Southeast Asia. So you all probably know about. I'm not trying to show the light on the sun, which is NIAC. So it's established as one of the premier non-profit alternative dispute resolution institution. And then we are serving on 8 Asia Pacific countries. And we are also a founding member of Asia Pacific Center of Arbitration and Mediation. So what that means is these are the some of the initiative trying to look into one, advancing ourselves as center of arbitration, where people could come and choose us as the seat of arbitration, and also choose arbitrators from our roster, and those things. And we're also trying to advance the awareness of arbitration in South Asia, not only in South Asia, but globally, but mainly focusing on South Asia. One, because arbitration is still underdeveloped. In I'll talk about that slightly later on, what I mean when I say arbitration is underdeveloped. But arbitration is still underdeveloped in South Asia. So that's one of the things. So how we're doing this now is this is the vision and mission. I don't I'll leave it for you to read that. So trying to develop as credible and accessible, two main thing. And the issue of credibility and then accessible area have in Asia. So not only within not only the dispute between anybody from Nepal involved, but also from outside. And one of the example I was looking was how London attracts the dispute, which doesn't have anything to do with London or English law. So that could be one of those things. One thing we're trying to do, our mission, promoting arbitration, creating awareness, developing the credibility by developing the framework. And some of the members, senior member of NIAC, I appreciate their lobbying with the government on changing the Arbitration Act and different other rules on those. So these are some of those initiatives what we have already taken. And then we also have started looking into international collaboration with different sort of international institutions. So these are the some of the services we provide within NIAC. I'm physically away from NIAC, but emotionally very much attached. So for those reasons, I'm saying we. So yeah, these are some of the services: arbitration, mediation, kind of a joint sort of hybrid sort of methods. Although within the law, adjudication has been removed from Public Procurement Act, but then we still provide that on there. So and then we provide service, but not only for the domestic, but also for the international client, as much as we are popular at the moment. So one of the thing what the initiative we are doing, we are taking is this sort of thing, training and capacity building, things such as workshop, seminar, and very shortly we are trying to go into certification program, trying to put chartered institute arbitrator, accredited, trainings and those. We have signed a lot of international MOU collaboration, particularly with big law firm, global law firms, as well as arbitration centers now. And you probably would know very soon we are hosting the ADR week in 2026, and aim to put a really good roster of internationally accredited dispute resolution professionals from our own training and capacity building programs. So yeah, we have already been in kind of a global forum. I've seen some of my, which I've missed here, some of our senior members going to Shanghai arbitration, programs and those. But yeah, been partnered on arbitration summit, Swiss arbitration summit, and those. So by all that, what we're trying to do is we are trying to promote a cross-border dispute resolution within the and then attracting and providing the awareness, and that's basically how we are looking into. So one of the thing I said earlier, one of the focus we had was on the credibility and accessibility. So how we're doing the credibility thing is, one of the most important aspect of arbitration is the impartiality, and competency and procedural integrity. So these three things are on the forefront of NIAC. One, we're trying to the reason why we are getting involved in in providing the trainings and certification and those, is one of the biggest emphasis we have is on the impartiality of the arbitrators. And impartiality is not the problem only in Nepal or Southeast Asia. Wherever you go, the impartiality, independence and impartiality has been one of the biggest issue internationally. So, where independence could be more objective, impartiality is basically seen from how somebody works. So, because it's a state of mind and when an arbitrator makes a decision, this has been one of the biggest dispute in most of the arbitration conference and the things I have attended, because impartiality has been very, very hard. So even when we go, there are certain guidelines the English court has laid down on the impartiality, which is basically looking into those principles such as principle of natural justice, um, the the the, the absence of the biasness. How do you prove was, again, it's very, very subjective, but then the court has laid down some principle, and then the arbitrators have been following those. But one of the major role of the institution is to ensure that the arbitrators who are in their roster, have acted credibly and impartially. That's one of the major thing. And to ensure that, one of the way where how we could ensure the arbitrators are credible and arbitrators are impartial is through the procedural impartiality and and transparency. So these are two of the things. In most of the places, we try to address these issues by declaration of interest, and those things. But at the same time, that's not enough, and that's why where the institution plays a very important role on ensuring that arbitrators are impartial and credible. So I'm not going to talk much on those. So until now, what we have done is we are trying to enhance Nepal's profile as a credible arbitration seat. Some of the incidents, I don't want to go into these, probably doesn't help, political situation and those, but still, as a business community, we probably could, whatever goes into the political terrain, the business is still business, and then the people could use us as kind of an effective forum of resolving their disputes. So that could be one of those things. So this is not only between Nepalese only, looking into not only the foreign investor with the foreign investor in Nepal, but also between other sort of parties as well. We could attract that and fostering that sort of culture on those. And as I mentioned, some of our senior members have been lobbying on various, changes in the law, in relation to arbitration and those. So this is what we are trying to do: is we are trying to be as a catalyst of a growth of arbitration, and not only in Nepal but beyond, within South Asia, and later on looking into the global player. How we are trying to do is we have got a publication underway at the moment, looking into publishing internationally accredited journal, where we could share our practices as well as learn from foreign practices, um, with that journal. So this is basically what we're trying to do as NIAC. So NIAC is coming as one of the institution which does actually provide this, not only the training and certification, but also looks in lobbying for the the legislative changes, lobbying for the conceptual changes as well, which is particularly hard. So yeah, this is basically how we are looking. I'm not going to be talking about this, but one of these things, the difference between institutional and ad hoc, I only put this slide here because we are talking about the role of the institution. When arbitration is an ad hoc, there's a kind of a higher risk of deadlock, and there's sometimes no administrative support. But then when we have an institution such as an IAC, that may help on breaking those deadlock on in arbitral proceeding, and those, and also could provide the administrative support. So this is that's one of the things. Earlier, I was talking about the you know the conceptual challenges we have in arbitration, and how do you make arbitration as a credible and yeah, a credible process, and how the institution could play the role in 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 making an arbitration as a credible process. So an institution, could play. This is an example I bring from the UK. So how institution has played a role on making an arbitration a credible process for dispute resolution. You could look from the data from there. There are thousands of arbitration in a year in the UK. I don't keep track of all other commercial relationship, but definitely do look into construction disputes. Construction is a business where there is a lot of dispute because the the contractor and the employer, you always try to put the blame onto another party, because one, the stake is very high, because the disputed amount could be not only on millions, could be on billions. So for those reasons, they always try to put the blame on another party. So for those reasons, there are every week there's so many construction arbitration that goes around, and this is the out of those thousands of arbitration, there were 46 appeals under Section 69, which is appeal on the error of the law. Arbitrators making, because not all arbitrators needs to be legally trained. So parties sometimes go for like try to um, you know avoid paying by going into that appeal. And out of 46, 9 only granted permissions. It's not an appeal, it's leave to appeal. So it's not that they have got their case entertained. The court has just said that yes, you can actually come for an appeal. So this is only 9 granted permission. And then there were, in this 22-23, 25 application under Section 68, which is basically irregular, sorry, things such as, what we call Section 68 is one of the thing where you would say, arbitrators have been, you know, um, not impartial. So this is kind of a challenges on that one. And then there were 8 applications under Section 67, which is basically saying the natural justice and those. And then, there are 5 pending at the moment, 2 dismissed, 1 discontinued. So from this, you could probably see when there is an arbitral award, the challenges to arbitral award is very, very less. They don't go challenging every arbitral award like what happens in Nepal. That's what I've heard. Like every arbitration is challenged. I was talking to some of the public prosecutors who look into, not really public prosecutors, sorry. I was talking to some of the people who look from the government's you know uh, being a government lawyer perspective, and then they said that yeah, if there is an arbitral award, we must go for challenging ones, and then only we'll ask the government office to pay. So this is completely a change of the shift in the completely a different perspective in the UK. Out of those thousands, these are only uh, the challenges. And if you look into the success rate on how many of them are successful, then the success rate is considered to be about less than 1% in the UK system, because the court always try to refrain from interfering on what the arbitration tribunal does and what the arbitrators does. Justice Foxton came about 2 years ago in one of the arbitration conference. It was in 2023, and Justice Foxton was telling that when you say arbitration as an alternative dispute resolution, uh, he said that arbitration probably is not an alternative dispute resolution um, for commercial dispute. It's actually a mainstream dispute resolution. He said that he was referring to the court system, the formal court system is an alternative for the commercial dispute. So this is how the arbitration is looked into, and this is what the cultural shift or commercial awareness we probably need to bring in Nepal. No, I'm not saying judges only needs to be aware of that, but if we're thinking about making arbitration, putting arbitration as an effective means of dispute resolution, we the stakeholders such as the lawyers, such as the arbitrators, they all need to be aware. They all need to focus on making arbitration as an incredible method of dispute resolution. So a party doesn't go to the court on their own. They go on lawyers' advice. So for those reasons, one of the thing, the whole perspective is, these days, what we try to do. I've been involved in things such as what we call the validation of the law courses around the universities here in the UK. And one of the things we are focusing in those revalidating the new courses is that the lawyer needs to be more proactive on dispute avoidance rather than dispute resolution. And this is what the shift is going to go now. We are more looking, lawyers are, rather than going to the court, lawyers in most of the Western countries are now being trained on dispute avoidance by by creating, by getting involved in compliance, and that's the kind of a new role for the lawyers now. So for those reasons, we as a group of lawyers, we probably need to be aware of that, you know um it doesn't mean like you disregard the interest of the party and not challenge when there has been something wrong in the process of arbitration or in the arbitral award. But at the same time, we need to be careful about challenging with the nonsense argument. So that's what we probably need to look into this one. So one of those things, the example I was giving, the success rate is less than 1% in the UK on challenging the arbitral awards, because the court isn't really interested in interfering on arbitral proceeding or arbitration institution. Having said that, the institutions do have their own challenges as well, and we as NIAC do not have. We are not any different than any other institution. So this is kind of a generic to all of the institutions, whether we are international or a regional institution. One, we need to be one of the things which is particularly hard for us as an institution is that quality control, because arbitration is there's confidentiality is one of the major philosophy of the arbitration, and why people would go on arbitration rather than going to the court is one of the thing is confidentiality as well. In most of the common law country, as soon as you go to the court, your business, your business is kind of a open book, and that's what people want to protect. You particularly the business secret and things, intellectual property and those things they want to protect on that. So when that does interfere with the quality control. So that's one of the things we probably need to. The most of the international and regional arbitration institutions are looking into how do you balance, how do you trade that very fine balance between quality control and the confidentiality, the issue of confidentiality. Another thing is because of the confidentiality, we do not publish the arbitral award. So how do you ensure the consistency? You know, because when you go to the court, you have got doctrine of judicial precedent, but you do not use that in here. So how do you ensure that there is consistency in those? So that's biggest challenge, and we do not have answer to those. But we do talk in many international forum on thinking about how do you do that. So this is one of the biggest issue that the institutions are looking into at the moment. At the moment, we do have digital transformation. Things such as virtual hearing, e-filings, they are kind of settled now after COVID. But at the same time, when you say digital transformation, it does bring a lot of challenges as well. So institution needs to look into particularly the security and safety of the data through during the virtual hearing and e-filing. So because it makes the data very much vulnerable, and because the parties to the arbitration, they come because of the confidentiality, and then also they do have their business secret. So one of the thing is really trying to looking to work into how do you improve that, and then who takes the responsibility when something happens that way. So that is one of the things the institution have been looking into and have started looking into, and we would be no different on those. That's why we're trying to go into publishing a journal as an IAC, publishing the journal, and trying to contribute on those, trying to learn from other people's experience on those. One of the thing in 21st century has been the diversity and inclusion. You know, I've been all summer. I've been working in reviewing my university's policy as one of the trustee and governor of the university, and one of that was, you probably heard, um, in on the 24th of April 2025, the Supreme Court decided, the case was the Omens, which is and the non-governmental organization versus the Scotland. And on that particular case, the court refused to recognize the a person with a gender reassignment certificate as a woman. They said that gender, the sex is the birth, right? So yeah, you could probably I'm not sure where you put on that, because that's not something I'm prepared to discuss today. But where the world is going, and recognizing transgender and all sorts of like binary, and all those. They refuse to recognize a person with a gender reassignment certificate as a woman. That changes a lot of things, and in there. So these are like types of the things. The issues are coming in now, diversity and inclusion. Because you may think that diversity and inclusion doesn't have anything to do with arbitration, but the perspective, sometime in a business, the perspective could be different, and the issue uh, could be related to those things, which is again from the level of development where we are. That probably is a small issue in Nepal, but then if we're thinking internationally, and that's something we need to be thinking about, the awareness of those sort of like diversity and inclusion and those. And then now we are also looking into, because these days climate change has been one of the biggest thing, and we people from Nepal know a lot better, because probably we have a lot more electrical cars in Nepal, because they are green. And we're talking about green arbitration practices. Previously, we used to have, the hard copy filing. Now going into e-filing probably could make arbitration more greener. But even within that, when you say, I was actually shocked once, when you send one email, you are actually creating a bit of pollution. I've got a colleague who does carbon accounting, and then he was telling me, when you actually send a you know block emails to number of people, you're actually creating more pollution. And I was thinking, how come that's not true? But that's actually true, because it goes to many people, not only you, and then the server works behind it, and then there is, yeah, you do create more pollution by sending unnecessary emails. And now we have been told in our institution, doing, rather than sending an email, do a Microsoft Team chat, because that's less, um, i- i- you know, less onerous on the server. So yeah, the green arbitration is another one. The issue of cost efficiency, like previously the arbitrators needed to fly from one to another place, could do online now. So for all those things, like this is something we are developing, but they come with a lot of challenges. The challenges is the main challenges at the moment is the digital transformation of the arbitration, and the institution needs to look into those things. So why I was talking about all those is to say one particular thing. The arbitration institution do have, um, they are indispensable in to the global arbitration, as a process, as well as the mechanism of dispute resolution, because they contribute a lot, not only on the policing is a very hard work, but very hard word on this. Not only policing the arbitrators, but also developing them and developing the process and framework. One of the things the institution does help is in ensuring the integrity, things such as access to justice, and ensuring the arbitrator follow the rule of law. And those, when you say access to justice, it's not about providing legal aid to people who couldn't, because that's probably not needed within the arbitration. But when you say access to justice, it's about the fairness. And also the institution do provide the innovation and as well as the regional collaboration, because it becomes a lot easier when it is an institution. And they are that's key to growth of arbitration, and particularly looking from the perspective of we as center of arbitration, because we're not well internationally recognized at the moment, and we're trying to I was trying to compare ourselves like NIAC with a young footballer who is trying to make a career on football. So when we're trying to do that, collaboration becomes quite important, and that's what we are trying to go into as an IAC. Not one, the collaboration also ensures a lot of other issues that we are dealing with. So that's why I was talking all about was, you know, the institution have a very big role in advancing the arbitration, and particularly for us, if we want to attract the parties to come and settle their dispute in as a seat of arbitration, then we need to do a lot of work, and those works have been started within the framework of NIAC. And I really appreciate to some of the senior members of NIAC who has been, um, you know, spending a lot of time and effort and making those effort on those. So that's kind of those. I would like to end with that one, but before I end, I would like to put this statement. No, this is not about uh, really commercial arbitration, and probably not a Barack Obama. Probably is not really a person to be referred in here. But again, this is really good statement he made. So when we say the disputes and dispute needs to resolve peacefully, whether it is international dispute between the states or whether it is dispute between the parties to the business, that needs to be resolved peacefully. And one of those peaceful mechanism is not going to the court. Once you go to the court, your business relationship is completely broken, shattered. And the way to protect that is through arbitration. Could be domestic, could be international. That's why I put this statement from Barack Obama, although he's not very popular. So that's where I want to stop now. I think I probably talked too much. So yeah, that's where I want to stop. And would be open for um, your observation, because I would learn a lot from that. Thank you very much.
धन्यवाद, धेरै धेरै धन्यवाद योगजी। तपाईँको प्रेजेन्टेसनबाट एकपटक आउट भइदिनु त।
Sorry.
ए भयो भयो भयो, यहीँ रहेछ टेक्नोलोजी, यहीँ रहेछ, थाहा नपाएर तपाईँलाई अनुरोध गरौँ। योगजी धेरै
And
धेरै
ठीक सर.
धन्यवाद। तपाईँको प्रस्तुति हामीलाई साह्रै कुरा दिनुभयो। हामी जस्तै प्रयास गरिरहेका छौँ त्यो पनि तपाईँले प्रश्न गर्न प्रयास गर्नुभयो। धेरै धेरै धन्यवाद छ, हामी आभारी छौँ। त्यति हुँदाहुँदै पनि केही कुरा भनेसम्म नेपाली नै बोलिदिनु होला। तपाईँ हामीलाई थाहा छ, नेपाली नै बोलिदिनु होला आफ्नो सहभागीहरूको यो प्रश्नोत्तर सत्रमा। एउटा सबको तर्फबाट एउटै जिज्ञासा हुन सक्छ, हामीले यो सेसनभन्दा अगाडि कोर्टले अनावश्यक इन्टरफेयर गर्छ, कहिलेकाहीँ कोर्ट सहयोगी पनि छ, कहिलेकाहीँ अनावश्यक इन्टरफेयर गरेर आर्बिट्रेसन सिस्टमले डिस्टर्ब गरिरहेको छ, हामीले यसो भन्यौँ। म प्रतिनिधि प्रश्नको रूपमा तपाईँलाई राख्दैछु, अरू साथीहरूको पनि आउँछ, सहभागीको पनि आउँछ। यसमा युकेको अनुभव के छ, हुनुपर्ने के हो,
धन्यवाद दाइ।
पहिला कलेक्सन गर्नुहुन्छ कि के गर्नुहुन्छ? यो चाहिँ पहिला क्वेसन कलेक्सन गर्नुहुन्छ?
हस्, हुन्छ हजुर।
पत्रिका दाइको नोट गर्नुहोस्, अरू साथीहरूको आउँछ नि त, ठिक छ? श्रीमान युवराज सुवेदी भनेर एउटा भन्नुभयो यो एप्लिकेसनमा, अर्को चाहिँ ट्रान्सपरेन्सी पनि भन्नुभयो। यो दुईटा कन्ट्राडिक्ट गर्छ कि गर्दैन? शब्द के हो?
प्रश्न
हजुर,
नाम समेत है, नाम समेत
प्रयासमा ज्ञावली। तपाईँले यस्तो सम्झिनु त,
मेरो क्वेसन के छ भन्दाखेरि च्यालेन्जेसको कुरा गर्नु भएको थियो नि, त्यो च्यालेन्जेस छ क्लियर पार्नु भन्नु सक्नु।
खास गरी पब्लिक पोलिसीको डेफिनेसन के हो, कति उहाँलाई सजिला र अन्त के फरक पर्छ भनेर।
यस च्यालेन्जेसहरु चाहिँ अपिल गर्न लाग्नु छ भन्ने कुरा एउटा त्यो भयो होइन, त्यो मैले क्लियर पार्नु पर्यो। अर्को कुरा भनेको चाहिँ के छ भन्दाखेरि हाम्रो बायसले गर्दा पनि इस्युहरू क्रिएट भइरहेको हुन्छ नि त, त्यो त्यसलाई कसरी डिल गर्ने त्यो एउटा अर्को क्वेसन भयो।
बायस हुन्छ कि हुँदैन, भोलिका पनि कस्तो समस्या आउँछ, कार्यान्वयनमा के हुन्छ,
च्यालेन्जेसको क्यान्सर कोर्टले युकेस कलेक्सनदेखि लिएर एभ्रिथिङमा एउटा इस्यु एउटा
कोर्ट कति सपोर्टिभ छ।
थ्याङ्क यू।
Okay, this is enough. Thank you.
Thank you.
तपाईँले अघि डेभलप र इन्स्टिट्युसनलमा हायर रिस्क अफ डेभलप र लोअर रिस्क अफ डेभलपको कुरा गर्नु भएको थियो, त्यसलाई थोरै प्र्याक्टिकल एक्जाम्पल दिएर थोरै क्लियर गरिदिनु।
ओके,
थ्याङ्क यू सागरजी।
ग्रीन आर्बिट्रेसन प्र्याक्टिसेस भनेर भनेको छ, त्यो गरिदियो भने च्यालेन्जेस एन्ड फ्युचर डाइरेक्सन्समा चाहिँ राम्रो हुन्छ भन्ने हिसाबले देखिएको अनि बुझिएको ग्रीन आर्बिट्रेसन प्र्याक्टिस।
फोटोमा हजुर प्लिज।
थ्याङ्क यू। अब सुरु गरौँ। पहिला मातृका ताईले नै सब त्यो डिस्कसनको लागि। हजुर
प्लिज।
क्वेसन सुन्दै हुनुहुन्छ यो गीत त्यो भयो।
हस्, धन्यवाद। पहिला चाहिँ अब मातृका दाइले गरेकैबाट डिस्कसनको लागि उठाउनु भएको इस्यु, कोर्टले चाहिँ अननेसेसरी इन्टरभेन्सन गर्छ भन्ने कुरा। त्यो भएर मैले चाहिँ लर्ड फक्सटनको एउटा स्टेटमेन्टबाट सुरु गरेका थिएँ, मैले यहाँ राख्न बिर्सेछु। उहाँले चाहिँ 2023 को यो उसमा आइसिसी कन्फरेन्समा चाहिँ युके सुप्रिम कोर्टको जजले कमर्सियल कोर्टको चेयरम्यानले राखेको चाहिँ त्यो ओपिनियन हो। अनि उहाँले चाहिँ त्यसले चाहिँ तपाईँको हाम्रो यहाँको युके कोर्टको अप्रोचलाई चाहिँ त्यसले क्लियर गर्छ। उहाँको भनाइ के थियो भने हामी कोर्टलाई चाहिँ मेन स्ट्रिम भनिरहेछौँ, मेन स्ट्रिम डिस्प्युट रेजोल्युसन फोरम भनिरहेछौँ। तर जस्तो यो कमर्सियल डिस्प्युटमा चाहिँ कोर्ट चाहिँ वास्तवमा मेन स्ट्रिम डिस्प्युट रेजोल्युसन फोरम हुँदै होइन। कोर्ट चाहिँ वास्तवमा यो अल्टरनेटिभ हो रादर देन मेन स्ट्रिम। त्यो चाहिँ उहाँले चाहिँ त्यसरी अप्रोच गर्नुभएको थियो। आर्बिट्रेसनलाई हामी कसरी हेर्ने भन्दा जस्तो त्यो कन्फरेन्समा उहाँले भनेको एउटा कुरा चाहिँ आर्बिट्रेसनलाई हामी कसरी हेर्ने भन्दा चाहिँ हामी चाहिँ आर्बिट्रेसन चाहिँ मेन वे हो भनेर चाहिँ त्यो चाहिँ कोर्टले युके कोर्ट चाहिँ इट्स लेस लाइकली टु इन्टरफेयर। त्यो भएर अब आर्बिट्रेसनलाई चाहिँ उनै गर्न दिनुपर्छ। के भन्छ आर्बिट्रेसनलाई चाहिँ त्यो इन्डिपेन्डेन्टली गर्न दिनुपर्छ। वेयर पार्टीले आर्बिट्रेसन मार्फत चाहिँ डिस्प्युट रिजल्भ गर्छु भनेर चुज गरिसकेको छ भने कोर्टले कुनै पनि हिसाबले त्यसमा इन्टरभेन गर्नु हुँदैन अनलेस देयर इज अ सिरियस एरर। त्यो प्रोसिड्युरल सिरियस इरेगुलारिटी भन्छ सेक्सन 68। अनलेस देयर इज अ सिरियस इरेगुलारिटी त्यो चाहिँ एब्सोल्युटली देखियो भने छुट्टै कुरा हो। नभए भने चाहिँ कोर्ट त्यसमा पस्नु हुँदैन भन्छ त्यो चाहिँ कोर्टको चाहिँ अप्रोच। त्यो भएर मैले भनेको अघि पनि राखेको थिएँ यो चाहिँ तपाईँको चाहिँ के भन्छ यो उसमा चाहिँ जस्तो लेस देन 1% सक्सेस रेट त्यो चाहिँ आर्बिट्रल अवार्ड चाहिँ सेट असाइड भएको होइन कि आर्बिट्रल अवार्डमा च्यालेन्जलाई कोर्टले लिभ दिएको, लिभ टु च्यालेन्ज अथवा लिभ टु अपिल भन्छ यहाँ। पहिला त्यो च्यालेन्ज गर्नलाई अथवा गर्नलाई चाहिँ कोर्टले अनुमति दिनुपर्छ भने हाम्रो जस्तो नेपालमा झगडिया झिकाएको जस्तो होइन, त्योभन्दा पनि अघिल्लो स्टेज हो यो। त्यहाँ जान नै पहिला पाउने कि पाइने पेपर एप्लिकेसन गरेर अनि उनीहरूले त्यसपछि बल्ल कोर्टले हेर्ने कि नहेर्ने भनेर दोस्रो स्टेजमा हेर्छ। सो अनि बल्ल त्यसपछि त्यो थर्ड स्टेजमा मात्रै हाम्रो त्यो अपिलमा झगडिया झिकाएको जस्तो हुन्छ यहाँ। अनि त्यसले गर्दाखेरि कोर्टको कन्सेप्ट चाहिँ कस्तो छ भने तपाईँको आर्बिट्रेसनलाई चाहिँ हामीले इन्टरफेयर गर्नु हुँदैन भन्ने चाहिँ त्यो अवेरनेस चाहिँ कोर्टमा एकदमै छ यहाँ। सर्टेन डिस्प्युटहरू छ जस्तो कि 2024मा एउटा केसको डिसिजन चाहिँ यो चाहिँ उसमा नै हो के अरे कन्स्ट्रक्सन डिस्प्युटमा नै हो। अनि एउटा केस थियो यो निकोलस जेम्स केयर होम र लिबर्टी होम्स भन्ने बिचमा केस थियो। त्यसमा चाहिँ यो उसले चाहिँ एडजुडिकेटरले आर्बिट्रेसन हुन्छ पछि कोर्टले चाहिँ आर्बिट्रेसनको हिसाबमा पनि बोलाएको छ यसमा। तर एडजुडिकेटरले चाहिँ एडभान्स पेमेन्ट माग्यो अनि त्यो मागेपछि अनि एडभान्स पेमेन्ट माग्दाखेरि चाहिँ एडभान्स पेमेन्ट नदिएको भएर मलाई हराइदियो भनेर ऊ चाहिँ गयो, त्यहाँ कोर्ट गयो। त्यो कोर्टमा चाहिँ उसले चाहिँ त्यो केसमा चाहिँ कोर्टले तपाईँको एडभान्स पेमेन्ट मागेको र नदिएको त्यो छुट्टै इस्यु हो। त्यो इस्युले एडजुडिकेटर चाहिँ बायस भयो भन्नु मिल्दैन। अनि यस्तो किसिमको केस लिएर आएर जस्तो एजुकेसन प्रोसेस अथवा आर्बिट्रेसन प्रोसेस अथवा अरू कुनै मेडिएसन प्रोसेसलाई चाहिँ स्टे गरिदियो भन्न चाहिँ आउन मिल्दैन। कोर्टले यसमा यस्तो टाइपको केसेसहरूमा इन्टरभेन गर्न मिल्दैन अनलेस उसको बायसनेस चाहिँ त्यो फेयर माइन्डेड टेस्टबाट नदेखिएसम्म त्यो यस्ता कुराहरूको आधारमा चाहिँ हामीले इन्टरभेन गर्न मिल्दैन भनेर यो चाहिँ टेक्नोलोजी एन्ड कन्स्ट्रक्सन कोर्टले बोलेको छ यो चाहिँ 2023मा। त्यस्तो थुप्रै इक्जाम्पलहरू छ जसमा चाहिँ कोर्टले यो त पार्टीले चुज गरिसकेको छ, पार्टीले चुज गरिसकेको कुरामा वी क्यानट गो इन्टु भनेर कोर्टले भनेको चाहिँ यति धेरै केसेसहरू छ। त्यो चाहिँ न्युमरस केसेसहरू छ यहाँ चाहिँ। अनि त्यसले गर्दाखेरि यो जुन कोर्टको अननेसेसरी इन्टरभेन्सन चाहिँ कोर्ट चाहिँ युके कोर्ट चाहिँ बेसिकली इङ्ग्लिस कोर्ट चाहिँ दे ट्राई टु अभोइड गेटिङ इन्भल्भ वेयर देयर इज एन आर्बिट्रेसन एग्रिमेन्ट। त्यो आर्बिट्रेसन एग्रिमेन्ट चाहिँ कम्प्लिट छैन भने पनि हामी यहाँ धेरै जस्तो प्याथोलोजिकल आर्बिट्रेसन एग्रिमेन्ट भन्छौँ। इभन इन त्यस्तो टाइपकोमा पनि कोर्टले चाहिँ होइन तिमीहरू गएर डिसाइड गर। अहिले त अस्ति एउटा पर्टिकुलर केसमा चाहिँ 2024को एउटा केसमा चाहिँ कोर्टमा भएको डिस्प्युटमा पनि पार्टिजलाई उनी डाइरेक्सन नै दिएको छ कोर्टले। यो कोर्ट चाहिँ यो केस चाहिँ कम्प्लेक्स छ, कन्स्ट्रक्सन केस हो, यो केस चाहिँ अलिकति कम्प्लेक्स छ। त्यो भएर कोर्ट भन्दा यो चाहिँ आर्बिट्रेसनबाट गर्न सजिलो हुन्छ, तिमीहरू गएर एग्री गर नै भनेर डाइरेक्सन दिएको छ कोर्टले। त्यो भएर कतिपय केसमा युके कोर्ट चाहिँ प्रो आर्बिट्रेसन छ रादर देन त्यो चाहिँ लर्ड फक्सटनकै स्टेटमेन्ट हो हामी चाहिँ प्रो आर्बिट्रेसन छौँ भन्ने। उनीहरूले आर्बिट्रेसन एग्रिमेन्ट भएर अनि आर्बिट्रेटर्सको चाहिँ अवार्डलाई चाहिँ उनीहरूले नर्मल्ली इन्टरभेन गर्दैन। त्यो भएर चाहिँ थुप्रो केसेसहरूमा कोर्टले चाहिँ हामी चाहिँ हाम्रो प्रोसेसले चाहिँ आर्बिट्रेसनलाई कन्ड्युसिभ हुनुपर्छ, आर्बिट्रेसनलाई सपोर्ट गर्नुपर्छ, नट डिस्करेज भनेर चाहिँ उनीहरूले धेरैमा बोलेको छ। र तपाईँको कुनै पनि चिजमा तपाईँ जानुभयो भने चाहिँ यो जस्तो यहाँ धेरै केसेसहरू छ आर्बिट्रेसन चलिराखेको छ भनेर स्टे भएको त सधैँ हुन्छ। एक दुईवटा केसेसहरू छ होइन आर्बिट्रेसन प्रोसिडिङलाई स्टे गरिदेऊ भनेको केसेसमा चाहिँ कोर्टले सधैँ नै रिफ्युज गरेको छ। आर्बिट्रेसन प्रोसेसलाई चाहिँ हामी स्टे गर्दैनौँ कहिले पनि भनेर भनेको चाहिँ थुप्रै केसेसहरू छ। त्यसले गर्दाखेरि युके कोर्टको अप्रोच चाहिँ वेयर दे लर्ड फक्सटनको एउटा आर्गुमेन्ट छ, वी सुड ओन्ली इन्टरभेन in the process of arbitration where it is absolutely necessary for the arbitration agreement to work। त्यो उनीहरूले भनेको आर्बिट्रेसन एग्रिमेन्ट र आर्बिट्रेसन प्रोसेसलाई नै वर्क गर्नलाई मात्रै हामी इन्टरफेयर गर्नुपर्छ, नभए भने चाहिँ हामीले इन्टरफेयर गर्नु हुँदैन भन्ने चाहिँ युके उसको चाहिँ कोर्टको अप्रोच छ। त्यो चाहिँ फेरि अर्को चाहिँ हाम्रो अहिले तपाईँले हेर्नुभयो भने चार्टर इन्स्टिट्युटको जस्तो सिपिडी ट्रेनिङ्सहरूमा सबैमा नै आर्बिट्रेटर्स अथवा काउन्सिल्स, हामी यहाँ लयर नर्मली काउन्सिल भन्छन्, काउन्सिल्सहरूलाई दिएको ट्रेनिङ नै के हुन्छ भने अनलेस देयर इज एब्सोल्युटली नेसेसरी हामी चाहिँ कोर्ट जानु हुँदैन, त्यो क्लाइन्टलाई कोर्ट जानलाई चाहिँ उक्साउनु हुँदैन, कोर्ट जानु हुँदैन भन्ने चाहिँ त्यो चाहिँ वान अफ द बिगेस्ट ट्रेनिङ अहिले चलिराखेको छ अवेरनेस लयरहरूमा। I don't know whether I answered that question. अर्को चाहिँ हाम्रो युवराजजीले अघि उठाउनु भएको त्यो ट्रान्सपेरेन्सी, कन्फ्लिक्ट बिट्विन ट्रान्सपेरेन्सी एन्ड कन्फिडेन्सियालिटी। अब ट्रान्सपेरेन्सी आर्बिट्रेसनमा when you say ट्रान्सपेरेन्सी भनेर चाहिँ बिट्विन द पार्टी मात्रै हो, तपाईँको पब्लिक ट्रान्सपेरेन्सी होइन। यसलाई चाहिँ हामी पब्लिक ट्रान्सपेरेन्सीको हिसाबले बुझ्दैनौँ। त्यो भएर त्यो ट्रेडिङ द फाइन ब्यालेन्स बिट्विन ट्रान्सपेरेन्सी एन्ड कन्फिडेन्सियालिटी। अब आर्बिट्रेटर्सहरू र पार्टीको बिचमा चाहिँ फुल ट्रान्सपेरेन्सी हुनुपर्छ, तर ट्रान्सपेरेन्सी भनेको इन्फर्मेसन पब्लिकमा जाने होइन। त्यो भएर त्यसमा चाहिँ कुनै त्यस्तो कन्फ्लिक्ट रहँदैन, किन भन्दा पार्टिज र आर्बिट्रेटर्सको बिचमा मात्रै ट्रान्सपेरेन्ट हुने हो प्रोसेस र त्यो आउटपुट सबै। त्यसले गर्दाखेरि त्यो बिचमा चाहिँ कुनै कन्फ्लिक्ट हुँदैन, किन भन्दा पार्टिज त जहिले पनि ट्रान्सपेरेन्ट हुनुपर्छ। देयर हेज बिन केस युके कोर्टमा चाहिँ मैले अहिले तत्काल नाम बिर्सेँ, तर आर्बिट्रेटरले एउटा पार्टीसँग चाहिँ अरू नै विषयमा इमेल कम्युनिकेसन गरेको उसमा चाहिँ पछि होइन अर्को आर्बिट्रेटर राख न त त्यो भइसक्यो भने च्यालेन्ज भइसक्यो भने भनेर चाहिँ गर्दा छ। अनि त्यसले गर्दाखेरि ट्रान्सपेरेन्सी र उसको बिचमा चाहिँ कुनै त्यस्तो 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 बिगेस्ट ऊ छैन। अर्को चाहिँ च्यालेन्जेस मैले त्यति राम्रो बुझिनँ, तर तर दुईटा चिजमा जस्तो लाग्यो त्यो च्यालेन्जेसको कुरा। एउटा चाहिँ बायसनेस, प्रयासमाको क्वेसन जस्तो लागेको थियो, बायस र अपिलको बिचमा। वान अफ द च्यालेन्जेस बायसनेस चाहिँ अब तपाईँको यो जस्तो छ नि, बायसनेसलाई चाहिँ कसरी डिफाइन गराएको छ भने आर्बिट्रेसनमा जहिले पनि एउटा प्रब्लम चाहिँ जहिले पनि भएको छ, सधैँ नै देयर इज एन इस्यु अफ फेयरनेस। किन भन्दा हामी अहिले पनि अब कतिपय ठाउँमा चाहिँ पर्टिकुलरली हाम्रो जस्तो कन्ट्रीमा, आई डोन्ट नो हाउ टु पुट दिस, कसरी राख्ने भन्ने चाहिँ, हाम्रो जस्तो कन्ट्रीमा चाहिँ जजेसहरूले नर्मल्ली धेरै जसो के सोध्छन् भने यु आर नट अ जज, यु आर एन आर्बिट्रेटर, डोन्ट ट्राई टु बी अ जज भन्ने चाहिँ त्यो हिसाबले सोध्छन्। अनि त्यसले गर्दाखेरि वान अफ द इस्यु चाहिँ बायसनेस चाहिँ त्यो बिगेस्ट च्यालेन्ज हो आर्बिट्रेसनमा। युकेमा अथवा वेस्टमा चाहिँ देयर आर सर्टेन प्रिन्सिपल लेट डाउन। म एकदमै पुरानो केस सम्झिन्छु बायसनेस चाहिँ के बायसनेस हो के बायसनेस होइन भनेर। अनि त्यसमा चाहिँ एउटा टेस्ट कोर्टले गरेको थियो, त्यो चाहिँ 2001तिरको केस हुनुपर्छ त्यो चाहिँ। अनि त्यसमा चाहिँ कोर्टले के भन्छ भन्दा बायसनेस इज फेयर माइन्डेड अब्जर्भर टेस्ट भन्छ। फेयर माइन्डेड अब्जर्भर टेस्ट भने चाहिँ त्यो मान्छे जसले जस्तो आर्बिट्रेटरले डिसाइड गर्दाखेरि कुनै पनि चिज डिसाइड गर्दा चाहिँ त्यो अब्जर्भर, आई एम एन अब्जर्भर भन्ने हिसाबले चाहिँ उसको माइन्डमा चाहिँ म अब्जर्भर मात्रै हुँ, मैले अहिले चाहिँ जस्तो यो बुझेकै छैन भन्ने हिसाबले उसले सुरु गर्नुपर्छ, त्यहाँबाट केही पनि बुझेको छैन, नो प्रि अकुपाइड कन्सेप्सन भन्छ होइन, त्यो नभइकन गर्नुपर्छ भन्ने चाहिँ त्यो एउटा ऊ छ। अनि त्यही हिसाबले नै जस्तो 2000तिरकै एउटा केसमा हो आर्बिट्रेटरको क्वालिफिकेसनको विषयमा कुरा गरेको छ त्यो पर्टिकुलर केसमा। मलाई लाग्छ लोको बेल भन्ने एउटा कम्पनीको केसमा छ, त्यो चाहिँ बेकफिल्ड प्रपर्टी भन्ने एउटा त्यो तिनीहरूको बिचमा भएको डिस्प्युटमा छ। अनि आर्बिट्रेटर कतिखेर डिस्क्वालिफाइड हुन्छ भन्ने कुरामा चाहिँ त्यो बेलामा चाहिँ कोर्टले एउटा प्रिन्सिपल के लेट डाउन गरेको छ भने वेन अ जज, त्यो क्वेसन चाहिँ कसरी आन्सर गर्न सकिन्छ भन्दा चाहिँ वेन अ जज कुड बी डिस्क्वालिफाइड टु सिट इन अ बेन्च, त्यो क्वेसनलाई चाहिँ सँगै राखेर हेऱ्यो भने आर्बिट्रेटर पनि ठ्याक्कै त्यही बेलामा मात्रै डिस्क्वालिफाइड हुन्छ भन्छ कोर्टले। त्यसमा त्यो चाहिँ अब जस्तो इन्ट्रेस्ट होला आर्बिट्रेटरको त्यो उसमा। अनि त्यसले गर्दाखेरि बायसनेस भन्ने कुरा चाहिँ वान अफ द प्रिन्सिपल चाहिँ त्यो बायसनेसको चाहिँ वान अफ द प्रिन्सिपल भने चाहिँ फेयर माइन्डेड टेस्ट हो। त्यो कुरालाई चाहिँ जस्तो 2010तिरको केसमा हो, एउटा केसमा चाहिँ यो त्यो कन्स्ट्रक्सन रिलेटेड केस हो। यो केस चाहिँ रोयल गार्डन होटल्सको केसमा 2010मा चाहिँ कोर्टले एउटा के भनेको छ भने बायसनेस चाहिँ फ्यान्सीफुल स्पेकुलेसन हुन सक्दैन। बायसनेस प्रुभ गर्नलाई चाहिँ आर्बिट्रेटर बायस भयो अथवा एजुडिकेटर बायस भयो भन्नको लागि चाहिँ it's not a fanciful speculation. You need to provide specific evidence how that biasness has affected on the decision making. त्यो चाहिँ तिमीले प्रुभ गर्नुपर्छ भन्छ। त्यो चाहिँ फ्यान्सिफुल स्पेकुलेसन हुन सक्दैन भन्छ त्यसले। अनि त्यो चाहिँ जस्तो त्यही बिचमा 15तिर एउटा केस आएको थियो, त्यसले चाहिँ अप्यारेन्ट बायस भन्छ भन्ने उसमा चाहिँ उ गरेछ। त्यो अप्यारेन्ट बायस चाहिँ कस्तो अवस्थामा हुन्छ भन्दा where arbitrator has taken undue advantage and where that is established, त्यो बेलामा मात्रै apparent biasness could be established भनेर चाहिँ कोर्टले 3-4वटा यो प्रिन्सिपलहरू चाहिँ ले डाउन गरेछ। त्यसले गर्दाखेरि वान अफ द थिङ बायसनेस भनेर चाहिँ इट्स अलवेज भेग यो कन्सेप्ट चाहिँ। त्यसले गर्दा यो चाहिँ बिगेस्ट च्यालेन्जेस नै हो बायसनेस चाहिँ। र जस्तो सेक्सन 68 च्यालेन्ज भनेर चाहिँ अप्यारेन्ट बायसनेसको आधारमा गर्ने च्यालेन्जेस हो युके आर्बिट्रेसन एक्टमा। आई बिलिभ नेपालको आर्बिट्रेसन एक्टमा पनि सिमिलर सर्ट अफ कन्सेप्ट छ। बायसनेस अथवा सिरियस इरेगुलारिटिजको आधारमा यु कुड च्यालेन्ज द आर्बिट्रल अवार्ड टु सेट असाइड। तर त्यो विषयमा जस्तो सामान्य इक्जाम्पल त्यो केसमा एडजुडिकेटरले एडभान्स पेमेन्ट माग्यो भनेर एडभान्स पेमेन्ट नदिने पार्टीसँग चाहिँ ऊ बायस हुन्छ कि हुँदैन भन्ने कुरामा चाहिँ कोर्टले के भन्यो भने एडभान्स पेमेन्ट मागेकै कारणले गर्दा र पार्टीले नदिएकै कारणले गर्दा चाहिँ एडजुडिकेटर बायस भयो भन्न सकिँदैन। यु निड टु पुट द फेयर माइन्डेड अब्जर्भर टेस्ट। if the adjudicator fails on that fair-minded observer test, then only you can say that there is a biasness. त्यो चाहिँ त्यो केले काम गराएको थियो त्यो बेलाको डिसिजन मेकिङमा र त्यसको असर कस्तो भयो भन्ने कुरामा मात्रै त्यसले चाहिँ गर्छ भन्ने चाहिँ त्यो कोर्टले इस्टाब्लिस गरेको प्रिन्सिपल छ। र अर्को कुरा त्यो डिक्लेरेसन अफ इन्ट्रेस्ट चाहिँ त्यो चाहिँ मेन प्रोसेस भएको भएर बायसनेस चाहिँ इट्स अ काइन्ड अफ अ भेरी हार्ड सब्जेक्ट म्याटर टु डिस्कस होइन। यो चाहिँ असाध्यै भेग पनि छ। त्यसले गर्दा सब्जेक्टिभ टेस्ट त्यस्तो कुनै छैन त्यहाँ। तर के हुन्छ भन्दा त्यो कोर्टले चाहिँ अनलेस देयर इज स्ट्रङ एभिडेन्स एगेन्स्ट, कोर्टले चाहिँ आर्बिट्रेटर अथवा एडजुडिकेटरको इन्टिग्रिटीमा चाहिँ क्वेसन गर्दैन यहाँ। र कसैले चाहिँ आर्बिट्रेटर अथवा एडजुडिकेटरको इन्टिग्रिटीमा क्वेसन गर्नु पर्यो भने चाहिँ त्यो मान्छेले चाहिँ यहाँ भन्ने गर्छन् देयर आर अ लट अफ आइरन अन द फायर। त्यो चाहिँ त्यो मान्छेले चाहिँ त्यसरी त्यो प्रुभ गर्नुपर्ने हुन्छ त्यो चाहिँ बायसनेसमा। अनि अर्को चाहिँ अपिलको क्वेसन उठाएको थियो मैले, क्वेसन चाहिँ राम्रोसँग बुझिनँ। त्यहाँको साउन्ड चाहिँ त्यति। हजुर क्वेसन चाहिँ मैले अब त्यो अपिल चाहिँ अब जस्तो यहाँ चाहिँ त्यो सक्सेस अफ अपिल त्यो छ नि सिरियस त्यो क्वेसन अफ लमा अपिल भनेर चाहिँ सक्सेस रेट चाहिँ असाध्यै सानो छ क्वेसन अफ लमा। त्यो चाहिँ एकदमै रेयर केस भन्दा हुन्छ। 0.2% सक्सेस रेट भन्छन् त्यो चाहिँ यो के भन्छ लिगल एररमा चाहिँ ऊ हुने चाहिँ। अनि अर्को चाहिँ त्यो इन्स्टिट्युसनल एडहकमा डेडलकको कुरा उठाएको थियो। यो चाहिँ सागरजीको कुरा होला जस्तो लाग्छ मलाई। त्यो चाहिँ जस्तो थुप्रो ठाउँमा मैले देखाएको छु एडहक आर्बिट्रेसनमा यो चाहिँ डेभलपिङ कन्ट्रीको मात्रै प्रब्लम नभएर डेभलप कन्ट्रीमा पनि एडहक आर्बिट्रेसनमा चाहिँ थुप्रो टाइम चाहिँ आर्बिट्रेटरले मलाई चाहिँ पार्टीले अपोइन्ट गरेको अनि मैले चाहिँ त्यो पार्टीप्रति लोयल हुनुपर्छ भन्ने सोच्दो रहेछ धेरै ठाउँमा। र अनि कतिपय ठाउँमा चाहिँ यो उनीलाई यो एकदमै कम हुने केस हो जहाँ आर्बिट्रेसनको कन्सेप्ट स्ट्रङ छ। तर जस्तो जहाँ आर्बिट्रेसनको कन्सेप्ट त्यति स्ट्रङ छैन, अवेरनेस छैन, पार्टीले चाहिँ आर्बिट्रेटरले चाहिँ मलाई त पार्टीले अपोइन्ट गरेको, मैले उसको इन्ट्रेस्ट पो प्रोटेक्ट गरिदिनुपर्छ त, म त जज होइन नि भन्ने सोच्दो रहेछ उसले। अनि त्यसले गर्दाखेरि धेरै ठाउँमा त्यो डेडलक हुने चान्स बढी हुन्छ। जस्तो त्यो चेयर आर्बिट्रेटरले चाहिँ एउटा भोट गर्न सक्ने भए पनि एकातिर बढी हुने भए पनि त्यो डेडलक हुन सक्ने चान्स चाहिँ बढी हुन्छ, किन भन्दा आर्बिट्रेटर्सको बिचमा चाहिँ नर्मल्ली युनानिमस डिसिजन होस् भन्ने चाहिँ कन्सेप्ट छ। त्यसले गर्दा डेडलक हुन सक्ने चान्स हुन्छ। र त्यसले गर्दाखेरि तपाईँको एडहक आर्बिट्रेसनमा चाहिँ कुनै इन्स्टिट्युसन हुँदैन। अब त्यो पुलिसिङ त नभनौँ, असाध्यै स्ट्रङ वर्ड भयो पुलिसिङ। त्यसलाई चाहिँ रेगुलेट गर्ने अथवा गाइड गर्ने कुनै इन्स्टिट्युसन नभएको भएर त्यो डेडलक हुने चान्स चाहिँ बढी हुन्छ। यो फेरि अब थुप्रो इस्युजहरू चाहिँ अब्जेक्टिभ नभएर सब्जेक्टिभ हुने भएर त्यो सर्टको डेडलक हुने चान्स चाहिँ अलिकति बढी हुन्छ। तर इन्स्टिट्युसन हुँदा चाहिँ कहिलेकाहीँ त्यो सजिलो हुन्छ, इन्स्टिट्युसनको आफ्नै रुल्स हुने भएको भएर। र अनि इन्स्टिट्युसन सपोज फर एन एक्जाम्पल आइसिसीको आर्टिकल 34 स्क्रुटनाइजेसन अफ अवार्ड, त्यसले चाहिँ त्यस्तो टाइपको डेडलक हुने चान्सलाई अलिकति कम गराउँछ इन्स्टिट्युसनमा। नहुने भन्ने त होइन, तर रेयरली हुन्छ इन्स्टिट्युसनल आर्बिट्रेसन भयो भने, फ्रेमवर्क भयो भने। मैले भन्न खोजेको चाहिँ त्यो थियो। आई डोन्ट नो अरू कुनै मैले मिस गरेँ कि। अनि ग्रिन आर्बिट्रेसन प्र्याक्टिस हजुर
छ भने हामीले फेरि लिन्छौँ। कोही छोटो छोटो प्रश्न छ भने उहाँलाई त्यहाँ राखी छोड्नु, नत्र सुत्न दिनु।
होइन, उठ्ने बेला भन्दा अहिले त 5:30 भइसक्यो।
कन्फिडेन्सियलिटीमा चाहिँ हामीले मेन्टेन गर्दै जाँदाखेरि त्यो बिजनेसहरू गर्ने त्यस्ता खालका फिलिङहरू गर्ने अवस्थाहरू डेभलप हुन्छ कि कस्तो लाग्यो के हो त्यसको
practices कुरा त्यो चाहिँ भन्छ।
यो चाहिँ योगमा मात्र अरू यही हामीले समाधान गर्नु मलाई धेरै तरिका आएको यसको प्र्याक्टिस त्यो हो छोटोमा व्याख्या गरिदिनु न।
हस्, थ्याङ्क यू दाइ। अब यो ग्रिन आर्बिट्रेसन प्र्याक्टिस चाहिँ जस्तो अहिले अब जस्तो कोभिड पछाडि चाहिँ थुप्रै आएको छ। यो जम्मै जस्तो थुप्रो चिजहरू हामी यो ग्रिन आर्बिट्रेसन प्र्याक्टिसको चाहिँ कन्सेप्ट यो पछाडि आएको छ। यहाँ चाहिँ एउटा क्याम्पेन नै आएको थियो एकपल्ट, क्याम्पेन फर ग्रिनर आर्बिट्रेसन भन्ने। त्यो चाहिँ एउटा एक्टिभिस्ट आर्बिट्रेसन एउटा एक्टिभिस्टले उ गरेको हो। त्यो चाहिँ लुसी ग्रिनवुड हो क्यारे उसको नाम। अनि उसले चाहिँ त्यो छ नि पहिला यो कोभिड अगाडिको कुरा हो। यो जुन डकुमेन्टेसन चाहिँ यति ठुलो हुन्छ आर्बिट्रेसनमा, त्यो फेरि अब सबै पार्टीलाई पठाउनु पर्यो, यो पार्टीलाई पनि पठाउनु पर्यो, ओ पार्टीलाई पनि पठाउनु पर्यो, सबै आर्बिट्रेटरलाई पठाउनु पर्यो। अनि त्यो कोर्ट प्रोसेसमा भन्दा बढी चाहिँ यो कार्बन प्रड्युस भयो, त्यसरी पेपर खर्च भयो अनि अरू चिज खर्च भयो, कार्बन प्रड्युस भयो भनेर चाहिँ त्यो क्याम्पेन उठाएको थियो। अनि त्यसले गर्दाखेरि अहिले चाहिँ जस्तो थुप्रै चिज कोभिड पछाडि त अब यो धेरै चिज चाहिँ उ भइसकेको छ। जस्तो इलेक्ट्रोनिक प्र्याक्टिसेसहरू भयो, भिडियो कन्फरेन्सिङ, यिनीहरू मिटिङ गरिराख्नु नपर्ने। अनि त्यो चाहिँ जस्तो हियरिङ भेन्यू पनि सस्टेनेबल हुनुपर्ने। अब जस्तो हाम्रोमा त्यति ठुलो समस्या नहोला नेपालमा, तर तपाईँको चाहिँ जस्तो यहाँ चाहिँ जाडो महिनामा तपाईँ जानुभयो र अब जस्तो कुनै भेन्यू चाहिँ जस्तो तताउनु पर्यो भेन्यू। अनि तपाईँ ग्यासबाट तताउने, घरहरू त ग्यासबाट तात्छ, ग्यासबाट तताउने भेन्यूहरू चाहिँ आर्बिट्रेटरहरूले रिफ्युज गर्ने भन्ने चाहिँ एउटा मुभमेन्ट नै चल्यो। जस्तो कि अब जस्तो सोलरबाट भएको हुनुपर्ने अथवा विन्डबाट भएको हुनुपर्ने। अनि कतिको त्यो जानुभन्दा अगाडि कतिको चाहिँ त्यो सस्टेनेबल छ त्यो प्रुभ गर्नुपर्ने उनीहरूले, भेन्यू दिने भने इन्स्टिट्युसनहरूले। त्यो चाहिँ त्यो थुप्रो चलिरहेछ। अनि त्यसरी अहिले यहाँ चाहिँ अर्को गजबको अहिले के चलिरहेछ भने हामी कहाँ त्यो आइपुग्न अलिकति टाइम लाग्ला। त्यो चाहिँ कार्बन एकाउन्टिङ गर्छन्। सबै तपाईँको जस्तो पब्लिक उहरूले चाहिँ कार्बन एकाउन्टिङ गर्नुपर्ने, अनि कार्बन अफसेटिङ गर्नुपर्ने, अनि त्यो मात्रै जस्तो आर्बिट्रेटर्सहरूले पनि त्यो युज गर्ने, त्यो कार्बन अकाउन्टिङ नगर्नेको भेन्यू युज नगर्ने, कार्बन अफसेटिङ नगर्नेको भेन्यू युज नगर्ने, त्यो चाहिँ त्यो एकदमै त्यो उ गराएको छ, त्यो चाहिँ त्यो छ नि, त्यसलाई चाहिँ इन्करेज गरेको छ। त्यो चाहिँ अहिलेको अब त्यो ग्रिन आर्बिट्रेसन प्र्याक्टिसेसमा चाहिँ हामी सस्टेनेबल सोर्स युज गरेको ठाउँमा मात्रै गएर हेयरिङ गर्छौँ, अथवा त्यो गर्नलाई सस्टेनेबल सोर्स युज गर्छौँ, अथवा हामी आफै विन्डबाट चाहिँ इलेक्ट्रिसिटी प्रड्युस गर्छौँ त्यसको लागि भनेर चाहिँ त्यो गर्ने चलन छ। अनि तपाईँको जस्तो कुनै भेन्यू, मेरो यो भेन्यूमा तिमीहरू आऊ भन्नलाई पनि आजकल चाहिँ त्यो छ नि, त्यो ठुलै अहिले उ नै भइसकेको छ। हामी चाहिँ यसरी सस्टेनेबल छौँ, अनि त्यहाँबाट निस्केको हामी कार्बनलाई यसरी अफसेट गर्छौँ भन्ने चाहिँ, अनि त्यो आर्बिट्रेटर्सहरूले पनि त्यो हेर्ने, त्यो चाहिँ अब मोर आर्बिट्रेसनको च्यालेन्जर आर्बिट्रेसनको भन्दा पनि त्यो आर्बिट्रेटर्सहरूले कसरी उ गर्ने भन्ने कुरालाई चाहिँ हो त्यो मेनली। त्यो चाहिँ आजकल खुबै भइरहेको छ यहाँ। अनि त्यो चाहिँ अहिले वान अफ द एकदम त्यो करेन्ट इनिसिएटिभ चाहिँ त्यहाँबाट गराएको छ, त्यो लुसी ग्रेनवुडको चाहिँ क्याम्पेनबाट सुरु भएको हो।
धन्यवाद, धेरै धेरै धन्यवाद। अब योगजीको यस्तो प्रस्तुति हामीलाई अलिअलि नयाँ पनि भयो, नयाँ कुरा सिक्न जान्न पनि पायौँ, र हामी सबै लाभान्वित भएको छौँ। आगामी दिनमा पनि जरुरी परेको कुरा योगजीलाई हामी सोध्छौँ, र हामी सबको तर्फबाट धेरै धेरै धन्यवाद।